First up this afternoon, we have Pamela Morgan, CEO of Third Key Solutions, and she's here to talk about DAM, which is the Decentralized Arbitration and Mediation Network.
You got it.
Which I think is, this year we've seen a lot of excitement over smart contracts and the idea that code will become law on its own, but I think we're seeing that maybe a bit of human intervention is going to be required for some time. So let's hear what Pamela has to say about that.
Thank you, Paul. Hi, everyone. How you doing? I'm really excited to be here. I don't know about you, but I'm absolutely thrilled to be here with you in London today. As Paul rightly said, today I'm going to talk to you about DAM, which is the Decentralized Arbitration and Mediation Network. And it's a project, one of our many projects at Third Key Solutions. So let's just get a couple things out of the way first. I know that when Bitcoiners see a QR code, you think payment, but this actually is not payment. So I'm not requesting tips from you. What this is this will take you to an article that I've written and published on Medium that will cover everything that I'm going to talk about right now. It also will include links to some things that I'm going to talk about, so you may find it useful. The QR code will also be at the end of the presentation. I am the CEO at Third Key Solutions, and Third Key Solutions is a key consulting and management company. We specialize in helping people secure their Bitcoin in a non-custodial manner. Again, non-custodial. So we also help people with estate planning. So for those of you, let's get a quick poll of the audience. Let's see who's here. How many of you in the audience have Bitcoin? All right, wow, almost all of you. Fantastic. All right, how about this? How many of you do not have Bitcoin? All right, look around, people. You need to help these people out. The ones who just raised their hand, we need to get them into the fold. Okay, great. And how many of you are working part-time or full-time in Bitcoin or some other cryptocurrency? Raise your hands. Fantastic. And how many of you are not but wish you were? All right, maybe like a quarter of you. Great. And just to understand a little bit more, how many entrepreneurs do we have in the audience? Quite a few, maybe 2/3. And how about designers? Do we have any UI, UX people in the house? Oh, just a few. We need these people. Look around. Those of you who are entrepreneurs, if you're not a designer, you need to hire them because our designs are not that great. Okay, how about journalists? Do we have any journalists in the house? Okay, fantastic. Good, good, good. All right, so I am an attorney. Don't hold that against me. I see some of you judging me already. I'm one of the good ones, for whatever that's worth. And I'm also a board member of the Cryptocurrency Certification Consortium. And that is a nonprofit that's based out of Toronto. And it helps to define standards. So we have CCSS, which is the Cryptocurrency Security Standard. What that is it's a standard for people who are building wallets, who are building applications, to make sure that they're building them securely. It was not designed by us, it was designed by the community. And you're welcome to take a look at it. They're free to implement on your own. So let's get started. Or not. There we go. Okay, right now we are facing a pandemic. I don't know if you know that or not, but we are. Due to the nature of Bitcoin and the fact that Bitcoin doesn't actually acknowledge national borders and doesn't require identity, we have a big problem. For those of you who are entrepreneurs and who are operating businesses in this space, for those of you who are consultants, who are consulting companies in this space, you have no idea what jurisdictions you are exposed to. That's a problem. That's a problem in business. So what do we do about it? Well, there's a vaccine. Great news, right? And it's really fairly easy to get. We have the freedom to opt out of traditional court systems. And that might sound like a revolutionary idea, and it might have been a while back, but it really isn't. It's just coming to us now. That vaccine is called arbitration. How many in this room are familiar with arbitration? Raise your hands. Great, so a good portion of you. And how many of you are already subject to an arbitration clause in a contract? Everybody. Do you have a credit card? Do you have a debit card? Do you have a banking relationship? You're subject to arbitration. You just didn't know it yet, okay? So these are standard terms in insurance, in banking, all of these. Arbitration is a standard part of almost every single contract, whether you know it or not. It has been used for decades by sophisticated parties who are doing cross-border transactions. And we can use this to our benefit. There's something called the New York Convention, and that's the shorthand for a series of international treaties. And what you need to know, what you care about, is that 156 jurisdictions have signed on to the New York Treaty. So the countries you see in blue are member states. What this means is that if you have an arbitration that happens in one of these countries, you can go to any of the other countries and seek enforcement there, and by way of international treaty, the local judge has to enforce the award. Yeah, so this is really powerful. Let's talk for a second about what would happen. So I'm based in Chicago, all right, in the US. I'm based in Chicago, and you're based here in London. So let's say we have a dispute. Let's say we don't have arbitration. You take me to court here. What happens? You get an award, right? How do you enforce it against me? Right, exactly. So what you would have to do is you'd have to come to local court in Chicago and ask the judge very nicely, "Oh, Your Honor, Your Excellence, would you please acknowledge this award and levy against Miss Morgan's assets?" And the judge can go, "Nah, no, I don't think so." Why? Because it's a judgment of a sovereign to a sovereign, right? And so there's nothing that requires a local court judge in Chicago to acknowledge an award that's based in London. Yes? Let's look at arbitration. If we had that same dispute in arbitration, but we had an arbitration award, you could take that local arbitration award, that was if the hearings were held here, it doesn't matter. You can take that local arbitration award, go to the court in Chicago and say, "Hello, Your Honor, I'm going to need you to go ahead and enforce this award by way of the New York Convention International Treaty. Thanks so much, bye-bye." And they have to, okay? And the reason they have to is because it's part of an international treaty. So we do away with the sovereignty of nation by way of the international treaty. Does that make sense? Powerful tool, much more powerful than a local court award. And that's why these multinational companies have been using it for decades. Most importantly, arbitration gives us the freedom to choose. We have choices that we never get in local courts. So let's look at these. First of all, substantive law. So those of you who write contracts, do we have any contract nerds in the house? How many of you like, okay, good. There's maybe like 8 of you, tops. Okay, I'm a super contract nerd. I like words, and I like contracts, and I like how you can use them to kind of help parties really understand what it is they're getting into, and hopefully resolve disputes before they become disputes. So that's why I like contracts. One of the things that we do in almost every contract, whether it's arbitration or not, is we choose substantive law. And all that means is we say, okay, according to this contract, within the terms of this contract, London law will apply, or Chicago law will apply. And by delineating which law applies, we then take the question mark and we take the risk out of, well, it really depends on where the lawsuit is brought as to what law applies, right? So then we can understand things like, what is a breach of contract? Well, a breach of contract is a certain number of elements, right? How do you figure out what a breach of contract is? Well, you have to look at local law and determine what those elements are. If you don't know what local law you're looking at, that means that then effectively you could be looking at any local law, depending on where someone brought a lawsuit. So if you say, we're going to take, for example, Chicago law, Illinois law, you then can look directly at Illinois law, and everyone understands, hopefully, what those elements are, and you can behave accordingly. You can also define procedure. So these are things like, all right, if you file an arbitration award against me, or if you file a claim, how long do I have to respond? I don't know. In federal court in the US is 21 days typically, but it could be different. It's different procedures for different courts. Now again, if you don't know what court you're going to be brought into, you don't know what procedures you'll have to follow. So you can actually determine what procedures you want to follow by way of contract. You can also choose venue, which means you can decide where the hearings are going to be held. And with arbitration, you can even say we want online hearings, and we want them to satisfy the requirements of an in-person hearing, if you so choose. This is, I think, one of the most important choices. With arbitration, you get to choose who your judges are. With traditional court, at least in the US, you get luck of the draw, right? It just depends on which judge is up, and that's the person you get. And they may not have any idea about the substantive nature of your case. They may have never done a case that deals with cryptocurrency, and I'll argue that most likely if you end up in front of a judge, you'll be the first. How do you feel about a guinea pig? No, you don't want to be that? Yeah, me neither. So arbitration gives us the option to say, at least one of the arbitrators needs to be an expert in cryptocurrency or whatever. And you can define what that means. What does an expert mean? You can define that in the contract. But here you actually get to choose who will be making the decisions on your case. And I think that's really powerful. You can also choose the number of judges. So you can say we're going to have one arbitrator or we're going to have a panel of 3 arbitrators. In theory, you could have as many as you want, as many as you're willing to pay. Although remember that the larger the group gets, the more difficult it is to make choices, right? So, but you have an option also of doing stepped. So you can say if, for example, our dispute is less than £1 million, we'll have 1 arbitrator. If it's 1 to 100 million, we'll have 3 arbitrators. And if it's over 100 million, we might have 5 or 7, right? You can make those choices that you can't otherwise make with local courts. You can also choose the language in which the hearings will be held. So you can say, we'll have all of the hearings in English, but you could also just as easily choose French or any other language that you feel comfortable with. This is another really great one. You can decide the duration of how long your case is going to take. So how many of you have heard nightmare stories about cases taking years, 5 years, 7 years? Yeah, in the US, it typically takes about 7 years at least to get to the US Supreme Court. And that's expedient, okay? So, do you really want these sorts of things hanging over your head for this long? For those of you that are entrepreneurs in this room, every minute that you spend dealing with a lawsuit is a minute that you spend away from building your business, right? And so now you have to have this duality of mind where you're dealing with this trouble that you don't want to deal with. Why deal with it? You don't have to if you choose arbitration. You can shrink that timeline down. You can shrink it down to as little as, I've seen clauses for as little as 6 months from the time you file a claim for arbitration until the time that the award is issued. 6 months. Which is a pretty short time, considering that that's the entire legal process. You can decide what evidence will be heard. Now, this doesn't mean that you get to say, no evidence that's damning to me, I have to turn over. It doesn't work like that, right? But you can say, we're going to make all of our decisions based upon the documents. We're not going to bring in 10 different witnesses for deposition and make people fly across the pond and do all of these different things and spend tons of money, right? Many common law countries have this problem where lawyers use depositions as a strategy to kind of elongate the process, right? So we try and make the process longer and more expensive to encourage settlement. And so you can actually try to avoid those sort of things by deciding that in our original contract, we're only going to do documents only. And then, if there's a need to have a deposition, both sides can agree. And it will be one deposition and not 5, 10, 15, 20, right? So you can actually cap. Confidentiality. So you can decide how confidential or not you want your proceedings to be. You can have them be confidential if you choose. You can have them be private. You can also have them be public. But again, this is a choice that you don't get with local courts. You can require that your arbitrators provide a written decision that proves why they came out a certain way. And that's helpful not only for the parties, but it can also be helpful for other people who are attempting to operate in the same space. You can also decide that you don't need a written decision. Again, that's up to you. You can also define the appeals process and who will be the appellate arbitrators, how long that process. So you can basically do all of this for appeals as well. So again, it's all about choice. Most importantly, and I talked about this briefly before, but I want to bring it up again, is the enforcement piece. So these arbitration awards are more powerful than a local court award in most circumstances, because their enforcement is by way of international treaty. In other words, it's not a request, it's a demand, although you should probably say it nicely. Ultimately, this represents the freedom to choose. So in our industry, we've heard a lot of this thing, we are not subject to jurisdiction. So how many of you have heard that phrase and heard people use it? Yeah, so sometimes people think that because we're operating online that we're not subject to jurisdiction. Like basically I think of it as a, you can't see me, or kind of a put your head in the sand sort of situation, right? Where, I'm not actually subject to jurisdiction because I'm operating in the ether. And that's simply not true. That also was not a comment on Ethereum. So I wrote an article a little while ago, and I called it Arial 11. And it's about the concept of default law. How many of you use Google Docs? Anyone? Have you ever used Google Docs? Okay, if you open a Google Doc and you start typing, what's the font? It's Arial 11. Are you stuck with Arial 11? No, you can Comic Sans it up if you want. No one's gonna stop you, okay? But if you don't make a choice, you will be stuck with Arial 11. The law is the same way in many instances. You have choices, but you have to exercise them. If you want something other than Arial 11, you have to make a conscious choice. And you do that by way of contract. You do that by way of making choices in writing, okay? So, another argument I've heard is the idea of I will quarantine myself. I will only do business with people who exercise complete anonymity, who do everything on Tor, who are absolutely perfect in their security. And just quickly, how many people in this room are absolutely perfect on security? Crickets, my friends, crickets, okay? We see no one here. So basically no one in this room is gonna do business with anyone else in this room. And for me, that's simply not an acceptable outcome. There has to be a better way. There has to be a better choice. And there is. So what can you do? First of all, you can elect to include arbitration in your contracts. This means for those of you who are writing software, in your terms and conditions. For those of you who are, I want to talk really quickly about founder agreements. Once again, how many of you are entrepreneurs in this room? Great. And how many of you have co-founders? All right, good. So probably half of you. All right, great. And how many of you have written founder agreements? Yeah, okay. So maybe half of those who are here have founder agreements. Kind of a personal question. Do you remember the first person you kissed? Okay, good, we've got smiles. All right, do you remember the first person who you felt that you were in love with? Yeah? Okay, great. How many of you are still with that person? Okay, all right. We have two out of like 120, 130 people. So when you are founding a company, you are in the honeymoon phase. You are in the I love you phase, and everything is wonderful. But as we've evidenced here, many times things do not end up as we want them to end up. And so if I can impress upon you one thing, for those of you who do not have founder agreements, please, please, please do that before the end of the year. Make this a priority. Go back to your offices and work out a founder's agreement. It's ugly, and it kind of sucks like a prenup. You're like, well, what happens if everything falls apart? Debbie Downer, no one wants to deal with that. Deal with it now. You'll save yourself a ton of time and heartache later. I promise you, it will be worth your time to do this. And when you do that, you should include an arbitration clause, or at least consider it, right? So that you can then define how any disputes are going to be handled later. Same thing for contractor agreements, same things for most contracts. There is a DIY clause builder. And this is through the American Arbitration Association. However, don't be put off by the fact that it's AAA and has American in the title. It actually allows you to select international rules. And what it will do is it will bring up a bunch of questions for you. So it'll say, hey, what kind of venue do you want? And you can click, and it'll let you choose kind of a stepped arbitration and mediation solution, those sorts of things. So if you're curious about it, you can just walk through it. It makes you, of course, sign off and say this is not legal advice because, yeah. But at the end of the day, it would be worth it for you to kind of take a look if you're curious about these things. And again, it's free, so it'll only take you about 10 or 15 minutes to go through. It's important to note that nothing is 100%. So we can never fully inoculate ourselves from the pandemic of local courts. However, these are effective in most cases. So arbitration will not protect you against criminal. You can't just decide that you're going to take the state to arbitration. Like, that doesn't work. And also, there are some instances, for example, if you have labor courts in your country, they may not allow you to take straight labor disputes to arbitration. There may be a public policy reason why they would not want you to go outside of the local courts. But it is much better than not having any protection at all. There are some side effects of bringing arbitration to our industry, and one of them is innovation. And I think that this is sorely needed in the legal community. How many of you are thrilled with the way the legal system operates now? Again, crickets. Okay, no one. Exactly. And so how do we get innovation into our court systems? Well, there are a couple schools of thought. One is, you go inside and you change the system from within, and God bless those people. I'm not one of them. I say we change it from the outside and try to escape that mess as much as possible and create something that actually serves people better on the outside, and maybe then the people on the inside will want to pull bits and pieces from it. So one of our hopes is that with DAM, if we start to build arbitration, we can then create a ground for innovation in legal services. What do I mean by that? A lot of times when you see typical arbitration contracts, it's not, okay, we have a dispute, boom, we go to arbitration. No, usually it's a step process where you say, okay, we have a dispute, let's go to negotiation. And then after negotiation, if we can't work it out, that's negotiating between the parties. Then we go to something called mediation. And mediation is where you bring in a third party, and they're effectively like a counselor. So they come in and they help you to decide on your own solution. That's important because they're not telling you what the solution will be. They're helping you discover a solution between yourselves. So, and then if that doesn't work, then typically you go to arbitration. And these steps can be flip-flopped, and there's lots of other hybrids out there. But why this matters for our context is that we don't necessarily have to have typical mediation. We could have a mediation DAO. We could have a prediction market. You could have maybe a crowd jury that comes in and you say, okay, we've decided we're going to submit our dispute to crowd jury, and we're going to let 100 people of our peers vote, and we're going to make our case like the People's Court. Do you guys have the People's Court here? Judge Judy? No? Okay. So effectively, you can do this sort of thing if you want to, right? And we can do it in a more professional way. But the idea is to explore alternative dispute resolution processes that allow us to have efficiency and that allow us to have more control over the processes. And by way, if we bring arbitration in as a floor, then we actually create a commercial viability for these alternative systems, right? If you don't have arbitration, can you elect to do crowd jury? Sure. But what's going to happen? You elect to do crowd jury, one person doesn't like the outcome, and where are you going? You're going to local court. So basically, you've effectively negated your crowd jury selection. Where if you include your arbitration award, you can say, we want the crowd jury to be part of the evidence in the arbitration. And then you haven't lost that time and effort. Or not. It's up to you. This is the thing I think is most important and most moving about arbitration. Our systems of justice today require identity. They have always required identity. But we have a problem because we operate in an identity optional environment, right? And so that then leaves us with a big problem. And the problem is that if you want access to justice, you have to give up your right to anonymity. And quite frankly, I don't think it has to be that way. I don't think that we should necessarily have to tie justice to identity. Imagine a world where it didn't matter if you were the CEO of a large banking institution like Wells Fargo. What if what you did was just judged on the merits of what you did? How would justice change? How would justice change if it didn't matter the color of your skin or the zip code or the counsel that you had representing you, but you were actually judged by what happened and what evidence you presented? Imagine a world like that. And I don't think we get there until we remove identity. And so one of the most beautiful things about Bitcoin and about other cryptocurrencies like Zcash is that by creating systems where we don't have identity presupposed, that is a catalyst for creating justice systems where we don't require identity. And I think that's the most meaningful way that we can go. So that's the DAM project. Basically, the idea is to create a decentralized arbitration and mediation network where we can make these ideas come to life. We are not looking to build a company. We're not looking to build proprietary software. We're interested in building open source solutions and working together with members of the community to build these sorts of solutions. And that's it. Thank you so much. Really interesting question. So I'm going to try and encapsulate that. The question is, we have a lack of precedent currently regarding cryptocurrencies. Would it be worth our time to basically create lawsuits on ourselves or do something in that way to create precedent? And I think that's a really interesting question. Here's a dirty little secret. And I should have said this earlier. I'm sorry I did not. Please pay attention. Nothing that I'm saying is legal advice, blah, blah, all the legal disclaimers, blah, blah, blah. Okay? And I have to say that because if you took all of this as my direct legal advice to you, I could be in trouble with the local bar where I'm based. So all of that said, here's the dirty little secret about precedent. Precedent is always viewed in terms of facts on the ground. And so this is why I think often we see problems with injustice, where we see a situation that seems very clear that, okay, this is negligence, 1, 2, 3, 4, 5. And yet the judge maybe finds the person not guilty of negligence. And the reason is because there are extenuating circumstances. And so yes, while I think precedent is important, and while I think it's important, for example, to prove that if you have a timestamp in the Bitcoin blockchain, for example, this is unalterable. And the reason that it's unalterable is because of proof of work and the immutability that goes along with that. And so if we can establish precedent in that way, I think that's hugely important. But the idea that we'll be able to establish precedent that will deal with every instance, I think, is what I would like to see are arbitrators and judges who are knowledgeable in this area. And I think by way of making sure that the decision makers are knowledgeable, we get to bypass some of the growing pains of precedent. Does that answer your question? Okay, great. Are we done? All right. One more.
One more quick. Two chambers. So I remember this is one of the most popular DAO proposals.
Yeah.
In the day.
Yeah.
At that time you asked for money to deliver something. Now you're saying this is open source project. Then what's that kind of outcome?
Great question. So for those of you that, yeah, I'm going to right now. For those of you that don't know, when we first launched this project, we launched it as part of, many people thought we launched it as part of the DAO. So we did launch this project on the DAO website, but we also announced it on our Ethereum and our Bitcoin. So the idea was what we were trying to test. Because the DAO had grown so large, so fast, we could see that there were going to be legal problems. And so we thought, all right, let's test the community and see if this is a good time. You know, for those of you that are entrepreneurs in the room, you know timing is everything. And so we know that our community needs these resources. The question is, when is the community ready to adopt them? And so we decided to test and see, okay, we've got the DAO, we've got money, will people be interested in supporting this sort of legal research? So phase 1 of our project was requesting a research grant, and effectively requesting an open source research grant where we would research and make our research available to the entire community. Since then, the DAO has imploded, as we know. But that doesn't mean that our community still doesn't need this. And so to the extent that we've been able to work on it without funding, we've done that. It isn't as far as I'd like to see it because of the lack of funding. At the same time, just between you and I, I'm not really willing to sell this out to a specific law firm or a specific venture capitalist who has their own agenda and their own vision for this project. I think it's most important that it remains open source and available to the community and available to be built upon. So if I could find someone that wanted to give funding for that, I'd be all in, but I have not actually identified them yet. So does that answer your question? Okay, great. Thank you so much. Thank you so much for your time and attention today.